Assalamualaikum doctor and the audience. We are from group 4. We would like to present the defense of insanity. Before we start, I would like to introduce our team members. First of all, RAIHANAH with the matric numbers 294699. Second, TING with matrix number 294722. Third, NIRANJIAN with matrix number 294725. Fourth, NURIN AZRINAZ AIMAN with matric number 294731. Fifth, FARHANA with matric numbers 294886. Sixth, with matrix number 294892. And lastly, myself, MARISSA with matrix number 295169. What is defense of insanity? I would like to give definition of defense. Defense literally stated that it is identifiable set of circumstance, condition, or situation which has the sufficient reason that provides sufficient reason why the accused is ought not to be convicted of a particular offences. Next, what is insanity? Insanity is a mental illness or disease that makes it impossible for a person or defendant to know they were committing a crime or understanding that their action is wrong or unlawful. There are three main provisions that are related to this topic, which is Section 84, 85, and 86. Section 84 gives the meanings of an action of incompetent individual, where it stated that nothing is an offense if the individual who made the crime, who do the crime, at the time of he made the crime, he is in unsoundness mind or mentally ill, which he can't understand the nature of the conduct, or it is incapable of knowing that it is unlawful or against the law. Section 85, there are two subsections, which subsection 1 stated that intoxication is not a defense under the criminal law. However, subsection 2 is stated the exception of intoxication, where it relates with the defense of insanity, since it stated about the unsoundness of mind, where he, the accused, did not know that he is in the such of act or omission is wrongful, where he can't understand the nature of his behavior, or that it is the intoxication or anything is without his consent, since he's went insane. Lastly, Section 86, which stated the effect of defense of insanity, where it stated that the burden of proof is under the accused person when he raised the defense of insanity. Since after he is proven the defense of insanity, he shall be acquitted, and with the following of Section 347 and 348 of Criminal Procedure Code, where he committed the action and he shall be kept in safe custody or be stayed in the psychiatric hospital.
Good day everyone, my name is NIRANJIAN, JOTHI, my matrix number is 29475. Today I'm going to talk about elements of defense of insanity. There are few elements. Firstly, unsoundness of mind. The accused must prove that at the time of the offense, they were experiencing a mental illness or other unsound state of mind, which is he is not stable. Their mental abilities should have been severely compromised by this illness, making it impossible for them to comprehend the nature and implications of their conduct, or to recognize that what they were doing was wrong. Secondly, the element is incapacity to understand the act. It must be proven that the accused mental instability prevented them from understanding the character and the extent of their conduct. This entails being aware of the consequences and ramifications of the action they took. Third and the last element of defense of insanity is unable to acknowledge wrongfulness. The accused must demonstrate that at the time of the offence, they were unable to recognize that their conduct was ethically or legally wrong. This is known as the incapacity to realize the wrongfulness. They were unable to distinguish between actions that are ethically or legally wrong and those that are accepted in the society.
There are 4 situations in which the criminal defense of insanity is applicable, which is firstly, is delusion, secondly, somnambulism, thirdly, irresistible impulse, and fourthly, insanity as a result of heavy intoxication.
Good day, Doctor. I'm Teo Kai Ting with the metric number of 294722, and I will be presenting one of the situations in which the defense of insanity is applicable. There are 4 situations, and one of them is delusion. Delusion is a symptom of psychotic illness in where it may be defined as a mistaken belief, which has for the patient the force of conviction and is firmly held despite all evidence to the contrary. Delusion also indicates an abnormality in the affected person's content of thought. A case to illustrate is the M. Nathan's case, which is also known as the first legal test of insanity, and it is still applicable up till now. The facts are the accused, Daniel M. Nathan, was suffering from a delusion that the Prime Minister of England was about to do something bad to him. Hence, he decided to kill the Prime Minister, but unfortunately, he ended up killing the Prime Minister's secretary, Edward Jumpman, who the accused strongly believed that he was the Prime Minister. Medical experts determined that his delusions broke down his sense of morals and drastically reduced his sense of self-control. Therefore, the accused pleaded not guilty by reason of insanity. The court eventually held that he couldn't be held responsible for the murder he committed, and he was acquitted of all charges on the grounds of insanity. The M. Nathan rule states that to establish a defense on the ground of insanity, it must be clearly proved that at the time of the committing of the act, the party accused was laboring under such a defect of reason from disease of the mind as not to know the nature and quality of the act he was doing, or if he did know it, that he did not know he was doing what was wrong. In conclusion, if the accused was insane at the time the crime was committed, they can't be guilty of the crime.
Assalamualaikum, I BINTI Dr. Marissa. My name is NURIN AZRINAZ and BINTI NORIZAM, and my matrix number is 294731. I will now explain about one of the situation where the criminal defense is applicable, which is somnambulism. Somnambulism can be defined as sleepwalking, and it is an unconscious state of mind. And if there is sufficient evidence that can prove the situation where it is you are unconscious, the accused is unconscious, then the accused will be acquitted under the provision in the penal code. I will now explain about the case that can be applied in somnambulism situation, which is a Ripapati Amal case. In this case, the accused had recently given birth to her child, and in one night, she actually jumped into the well with her child, and the child drowned while she was safe when the alert was set off. The defendant was accused for attempting suicide and also murder. So, in this case, she backs her defense that she was sleepwalking and she had to enter the well while she was sleepwalking. The court in this case decided that the defense of automatism cannot be applied, and if the somnambulism or sleepwalking can be proven with sufficient evidence, then the provision, which is section 84 under the penal code, is the only relevant provision that can be used for defense against the accused. That's all from me. Thank you.
Okay, moving on to the next situation, which is irresistible impulse. So, an irresistible impulse shows a loss of control. However, it does not indicate unsoundness of mind, and it cannot be a defense under the law unless it is proved that the irresistible impulse itself is the result of insanity. So, based on the case of Juso versus public prosecutor, it is said that the appellant had ran amok without any apparent reason, resulting to him slashing his sister-in-law, inflicting 12 wounds on her, and causing the death of her 2 children with a parang. And he also killed a stranger and inflicted several injuries on 2 other men. And as a result, a medical officer of the case described that the appellant was in a daze and was overwhelmed with deep grievances and sorrow. Therefore, in this case, it was held that the court allowed his appeal on the ground that Juso was suffering from mania, which would produce in him an irresistible impulse to do what he did at the time of his acts of killing. And even though irresistible impulse is not a defense under the law, his type of mania, however, generally produces the consequence that the sufferer has no idea what he was doing was wrong. Thus, it is said that the plea of insanity under this case is acceptable.
Next, the fourth situation in which the criminal defense is applicable is insanity as a result of heavy intoxication. Heavy intoxication that causes insanity is also a defense according to the provision in the penal code if it make a person incapable of understanding what he is doing or that what he is doing is something wrong or illegal. The accused must prove that at the time of the act or emission, he was by reason of the intoxication insane, temporary or otherwise. So, in the case of public prosecutor and Tan Hotek, the accused was charged for murder of his brother by stabbing him to death. The accused had consumed a whole bottle of brandy, and while intoxicated, he fatally stabbed his brother. The defense provided that the accused was very heavily intoxicated and that he had no idea of what he is doing and he did not have any intention to stab his brother. The court is satisfied that the accused at the killing time was suffering from delirium tremens due to acute alcoholic intoxication, which caused him incapable of knowing what nature of his act or what he was doing.
Greetings to Dr. Yusramiza, greetings to everyone. I'm Eung Ziyu with the matrix number 294892. I'll be presenting our group's opinion on criminal defense. The defense of insanity under Section 84 of Penal Code is a crucial aspect of criminal law, as it recognizes a person who suffered from mental illness may not have the capacity to understand the consequences of their actions. It serves as a safeguard against punishing a person who are not morally culpable due to their mental health condition. From our perspective, Section 84 of Penal Codes regarding insanity defense is believed to be out of date, as it was based on the rule of M. Norton Rule, which introduced the concept of criminal culpability and mental illness into the 19th century thought. It may not be able to adequately address the complexity of mental illness nowadays, potentially leading to the exclusion of some person who suffer from mental illness but fails to meet the narrow criteria. As we live in 21st centuries, there have been significant advancement in understanding of mental health. Modern psychiatry and modern psychology offer deeper insight on what is mental illness. Updating the law to reflect these advancements is crucial to ensure a comprehensive evaluation of criminal cases. With that, I shall end my session. Thank you very much.